As an estate and elder law attorney, one of the questions I get most often is how do I avoid probate in Alabama? So probate is a process that is required if you have assets that are just in your own name whenever you pass away. So that process takes anywhere from a minimum of about 8 months, sometimes a year and a half, just depending on what all is involved, how many creditors there are, how many heirs there are, and things like that. But probate is basically the process to get assets from a deceased person's estate to the heirs or beneficiaries. And so again, it's a court process. It can be expensive and time consuming. In most cases, it requires hearings. If you have a will, it makes it a lot easier. Probate's a lot easier than if you pass away and don't have a will. But either way, probate can be a long process. Again, it takes a lot of hearings. There are court costs involved and things like that. So people often ask, well, how can I avoid that? So there are basically 3 ways to pass title to assets. Number 1 is you can own those assets jointly with someone else and have a survivorship provision on there. So like if you own your house with your husband or wife, chances are your deed says it's owned joint with right of survivorship, which means when one of you passes away, then the other one owns the asset and it doesn't have to go through the probate process. People can also own bank accounts and things like that jointly with right of survivorship. Now don't confuse just the fact that you own it jointly that necessarily has a survivorship provision. You'd have to set the account up that way. So some accounts are owned jointly, and one dies, then their half of the account still has to go through the probate process because there wasn't a survivorship provision, and the other person owns half of the account. The other way to transfer title to assets is with beneficiary designations. And we typically see this with life insurance and IRAs, 401ks, and things like that. You just name someone as the beneficiary. So when you pass away, they send in a death certificate to the insurance company or the company that has the IRA, and those proceeds are paid directly to that person. They don't go through the probate process and therefore aren't governed by your will. So one of the things that people get really messed up on is that they think their will, whatever their will says, is how their assets are going to be divided. I've had numerous cases where someone's will says I leave everything to my 3 kids equally, and yet the oldest child is named on the life insurance and IRAs, and they wind up getting all those assets, and only the probate assets are divided in 3 ways. So you have to be very careful about that. The other way to pass title to assets is you can have them in a trust. So if assets are owned by a trust, then the trust says, while I'm alive, I'm going to manage them if I'm competent. If I become incompetent, I have a backup trustee. But when I die, then I want the assets that are owned by this trust to go directly to my heirs or whoever you name as the beneficiary of the trust. And those assets also skip probate. So just to recap a little, because this can be confusing, probate is only for assets that are just in your name when you pass away that don't otherwise pass by operation of law. So if those assets are jointly owned with a survivorship provision, they avoid probate. If the asset has a beneficiary designation on it, then again, that asset avoids probate, goes directly to the beneficiary. And if the asset is owned by a trust and you pass away, then that asset or those assets inside the trust pass to the beneficiaries as they are laid out inside the trust. So those are the ways to avoid probate: have survivorship accounts, have beneficiary designated accounts, or have them owned by a trust. If you have other questions, then I encourage you to give us a call. Hope that this video was helpful to you.